Good morning, welcome to 59 Minutes. My name is Levi Kones. This morning we are going to be discussing matters to do with the law, talking about things about the law you should know, and especially focusing on matters to do with family law. To join us in that discussion is a lady who is an advocate of the High Court. Her name is Grace NTEERE. Karibu sana.
Thank you so much.
Have I got your name right?
No. Grace NTEERE.
NTEERE.
Yes.
Oh, okay, it's the end up on NTEERE.
Yes.
Karibu sana, Grace.
Asante sana.
Glad to have you here.
Thank you for having me.
All right, when we talk about family law, what are we talking about?
As the name suggests itself, we are talking about family. What's the definition of a family? Some will say a father, mother, and children. Some will say the extended family or the entire nuclear family. But in law, the Constitution defines a family as a unit, a unit that is actually protected by the law. And in this unit, there are specific measures or specific, like a limit of where should this get to in terms of family when you're addressing issues to surround a family, like when you're talking about family law. Family law is a broad topic that we cannot cover, let's say, in one sitting. It is a discussion that, or an awareness that everyone needs to at least have an idea of what it talks about. Because family law incorporates children and the law. It incorporates property, matrimonial property. It incorporates succession, which is again a very broad topic and a very important topic that we should be, you should be aware of. Not only me as an advocate, but you as my client or my potential client, because at any given point, you are part of that unit that the Constitution offers protection. So for you to be able to know what protection the Constitution and the subsequent legislations that are giving now effect to the constitutional provision are saying, you need to know exactly when this issue arises, let's say an issue of succession, how do I deal with it? And all this is around family law. Okay,
I want us to start there with the succession law because usually what happens is because the succession will come because we have interacted with death of a family member. And for many of us, it's not something we want to talk about because we,
we are Africans, just say that. Every African is afraid of actually death.
We feel spooked, yes.
Yes.
But yet people die in our families and then now we don't even know where to start from.
Yes. Levi, I'll tell you, that is an issue that is alive with us. It is here with us, especially now that we have COVID. And people should actually take care because COVID, it's taking people. And not just people who are on TV or out there in Nairobi or somewhere else. Your immediate neighbor could go. And you're left there wondering, now, where do we start from? What do we do?
What do we do?
That's where succession comes in.
So just tell us in the basics, let's, if a parent has died in a home, ideally,
what should happen?
Yes, what should happen? What's the procedure?
The procedure. Now, Levi, if somebody passes on, either, let's say a parent,
let's talk about the father specifically, because usually that's
the head of the family.
Things,
yes. What usually happens, of course, everyone will be trying to identify the property that this person had. Because this property now, if he was managing something, let's say her farm, we need to know so that we appoint somebody to take care of it in case there was no one who was directly tasked with taking care of that farm. Because you can't say now that this person is dead, life stops. Life has to go on. And for life to go on, we need to take up what this person was doing and try and, if it's a business, it needs to keep running. So what happens when somebody passes on, let's say a father? After, of course, the burial, you will get all the necessary documentation. As the family, or let's say the wife, you need to file for something called succession. They call it generally succession. But this will depend on one thing. Did this person have a will? Or didn't he have a will? Okay,
let's start there. Now that is the obligation of the deceased.
Yes.
To have a will or not.
Yes.
What would you say about that?
Number one, before we even dwell into what a will is and what it's not, number one, my advice would be, even to you, Levi, just have a will. It's not a document that requires rocket science to tackle or to draft or to prepare. It's a document that you yourself will prepare to show, this is what I have, these are my beneficiaries, and this is what I give to so-and-so. You are the testator. By then, you will be the testator. You are actually listing all your property. You are actually listing all the interests that you have, let's say shares, they could be companies and whatnot. You're actually planning your life. But as fate would have it, we as Africans, no one wants to hear about prepare a will. Where I come from, they will tell you, no, you are actually predicting death on yourself if you prepare a will. But from a legal point of view, and my advice as an advocate who has interacted with some of these issues, it is actually proper to have a will.
Yeah, and of course, by now, many of us have seen, news items of prominent people and families that have gone through, sheer hell after.
Actually, they're actually caught wrangles running to up to 20 years because you're fighting over property of somebody who died 20 years ago. But as a family, you cannot agree. People go to an extent of killing each other because of the property that you left behind as a father. To avoid all these issues in family, I think you know your beneficiaries, just list your properties, allocate them. Leave them in the hands of somebody. If your children are very young, they're not yet 18, just list them. You can always amend the will, because somebody now, the next question will be, how do I draft a will? Who does it for me? I was
going to go there.
Yes.
Yeah. How do I make sure that what I've written
is correct?
Is correct actually, and will actually carry the day.
Will carry the day. Because actually, I will tell you, you might try something thinking it's a will, and once you're gone, because a will only becomes effective after death, not before death.
Yeah. Someone contests it.
Yeah, they will contest in court, and if the right provisions are not there, it will be invalidated and your estate will be administered as if you died without a will. So you will not actually have helped. So number one, get a lawyer to do you a will. Some will say lawyers are expensive, and you would not want to expose yourself to, somebody else knows your property. But I'll tell you, there's something called lawyer-client confidentiality. If you come to me and you want to do your will, of course, I'll tell you we can do it, but your next question will be, where will I store it? I'll come to that. Where can you store your will safely? Because we've had issues where somebody has done a will, they actually live here with us, and then some of the beneficiaries somehow get to know that I'm listed as a beneficiary in my father's estate. Do you know what they do next, Levi? They'll plot to kill you so that they inherit.
So that they can start the succession.
Definitely, because they know this will not take effect until you're dead. So number one, get a lawyer to do your will.
Okay. And what does that entail? When you're telling people get a lawyer to do your will.
That's what I'm coming to. Yeah. Number one, for a valid will, first of all, it needs to be done by the testator. At that point, you're not the deceased. You're the testator.
Which means that you're the person?
You're the person who is actually giving these instructions. Okay. So it will be you and your lawyer. You sit down, tell him to write this. Not under duress, not under undue influence. It is out of your own volition. You're sitting down and saying, yes, I own this property, and in case of my demise, let it go to so and so, so and so, so and so. One mistake people make, Levi, you might have a child that you don't like so much, and you decide to exclude them from the will. From the will. That child can actually go to court and challenge it, and it will be, all your effort will have gone to vain. So number one, you cannot disinherit. You as a testator, it is your property. You cannot disinherit your rightful beneficiaries. Because when you look at the law, legal. It's legal. The Law of Succession Act actually says that. It lists the list of beneficiaries, starting with your spouse, your children, then your parents, in that order, up to the sixth, we call it the 6th degree of consanguinity. So that in case you have property, you've died, and no one up to the 6th degree of consanguinity can be traced, that property now devolves to the state. You get me? But you cannot disinherit your child and then go to, give a cousin to your wife's brother property. You can't do that. That will be challenged, and your estate will be administered.
So it's your will, but it's not really your will.
Yes.
It has parameters.
It has parameters, of course, to ensure that, again, there is no discrimination. The Constitution is actually clear and against discrimination for whatever reason. You cannot discriminate. Whether you liked me or you didn't like me, whether you wanted me to do law and then I went and did medicine, you can't say, no, this one disobeyed me, I will not give you anything. Yeah. So, number two, a proper will has to be executed properly. That is to mean you have your witnesses, probably an advocate, and you as the testator, you need to validly sign against that will. So that at the end of the day, even if you are going to store it anywhere, this will has your original signature, and no one can tamper with it. And you are signing, let's say, against each page saying, yes, these are the instructions, this is what I wanted, imeandikwa, let's go, let's do this. You sign it. And number three, you cannot do, how would I call it? You cannot do a will like partially. You know, you will go and invalidate it for one reason. You just listed 4 properties. You have 8 properties. There is a provision, of course, for amendment. But for amendment, it also has to be in the form in which the original will was. And you need, if it was in writing and signed on every page, it needs to be the same way and clearly state that, you know, you're revoking the previous one.
So I come to the legal office with my witnesses. How many?
2.
Should they be relatives? Should they be anyone?
Well, I would discourage to have relatives as witnesses.
Because of leakage.
Yes.
And
for obvious reasons. For obvious reasons that they might be tempted. In as much as you trust this person so much, they might be tempted to say, you know, baba yako alikuachia the 50 acres. And you're like, okay, I'm suffering out here and my father somewhere, there's a document somewhere saying, you know, I need 50 acres. Ama you are laid off in your job and you know you have some credible information saying that your father left the company to you. That will be tempting. So I usually advise my clients, get a friend, a close friend, to have it witnessed. Or better still, if you do not even trust that friend, let another advocate come and sign it for you. Somebody who doesn't know anything about your family. Let them come and witness.
So you do that, you've written your things there, you have done your signatures.
You actually I forgot to mention, you appoint somebody to administer the estate. To
execute,
Yeah. So this person will be told, will be listed like, I have children who are, 15 years old. This person will be like a trustee, you will be appointed as a trustee to hold this property in trust of the children until they are 18, then you can transfer the property to them. So you actually, when you're doing a will, it's something that you need to think about seriously.
Yeah. Can the trustee mess you up?
The trustee can mess you up, but there are ways to counter that. You can actually take them to court. If you feel like an administrator who was appointed on the will to administer the estate is not administering as it should be, you can actually go to court and challenge. This person will be called to give an account of the estate of the deceased. So if he mishandled or mismanaged the estate of the deceased or the proceeds of the estate of the deceased, then you'll be held accountable.
Okay, so you've done your will, you've listed your things, you've got your trustees, and you've said who will execute.
Where do you store it?
Yes, and you've got your witnesses. Now the will is complete.
The will is complete.
So now what?
Now, most clients leave the will with the advocate for them to store. Others have fears, of course. Your office might be broken into if people know that there's a will lying somewhere and they have all reasons to believe that it's in your office. Your office might be broken into and it's lost. For me, what I advise my client, you can store your will at the bank. The bank will keep it for you. Deposit it at the bank, they will keep it for you.
Yeah.
Yeah.
And at what point will this will, you know, come to the fore?
Now,
how will we know there was a will if you had left it in your bank, in your own personal artifacts?
Of course.
Or with your lawyer, maybe.
Now, when you leave it with me as your lawyer, definitely I'll know when you're gone. I'll know my client has passed on. So after the burial, or after all the family has settled down after the burial, I'll go and tell them, this person was my client, he had a will, yeah, it is.
So there's a trust issue here.
Yes.
Should you have a copy somewhere else then?
No. For me, I don't need to have a copy because...
No. For the person who has done the will, should they have a copy with you and a copy with someone else, just in case, you know, if your lawyer is not there, or your lawyer is compromised, or your lawyer dies?
You see, mostly, I'm not coming to you.
Then who knows? You know, these are things people ask out there.
Yeah, definitely, and they're actually very valid questions.
Yeah.
For me, when I'm coming to you, if you are my client, a person, when I'm going to your family, I'll not go to your wife and tell her, this is the will. They might actually even, you know, snatch it. What usually happens, I'll advise you and tell you, I have it, I've not opened it, because you need to seal it properly. I cannot break that seal. We need to go to court. Because even for a will, where you die tested, we call it tested succession, you need to go to court for the court to validate the will and say, okay, the property can now be divided as the deceased wished. So you still need to go to court.
So there's a seal.
Yeah, there's a seal. It needs to be sealed. The proper will, you will need to seal it. And I cannot break that seal. I'll just come and inform your family that you left a will. We can start the processes. And starting the processes will start from, you know, getting even a chief's letter. That's for intestate succession where there was no will. But most people, as we know, Africans, the way we are, there are some who will look and see, I did not like this person. Let us do the succession without including them. That's another issue altogether. It won't go through, honestly speaking. Because somehow they will find out. For intestacy, it's quite a lengthy process.
Okay.
Because it needs to go through Kenya Gazette, all the properties need to be listed, and probably you're excluding somebody who knows where the property of this person is. You're excluding a direct beneficiary. That will become a difficult issue. Yes.
Yeah.
So for a will, when you have all your documents in order, I think it makes work easier for your family to actually be able to even deal with your death. Because now if you bring issues, you're dead and, you know, people are fighting, they can't even get over you're actually leaving them more problems. More problems. So that's why I actually advise people to do.
So that's for people who have done wills.
Wills.
There's a process you can do that, and that will be, you know, be able to be executed quite well. What about the vast majority who are like, you know what? Let it be what it will be. The vast majority. Yeah. Intestate succession. That's so if your person has died, yes, and now there's no will, unaanza wapi? Number one, unaanza, you get the burial permit or the death certificate, because this is a journey that will, you know, you will take some time. You need the death certificate or the burial permit. You need a letter from the chief of your area saying that, yes, I knew this person died, and these are the beneficiaries. That's what I was talking about. Some families go to the chief and compromise the chief to write a letter excluding others. Oh, so the chief is supposed to list your family as the beneficiaries, yes. Because the same as for tested succession, the order of consanguinity still supersedes. So you'll not start gifting, you know, allocating property to your aunties and your uncles while the children are here suffering. So for tested succession, you will get that letter. You will go to a lawyer. For actually succession, it's very easy because the forms are standard. There's what we call the Law of Succession Act. The forms are at the schedule at the back. You can actually do it for yourself. These are standard forms. You fill a petition. It's called a petition, a succession petition. Probably you are the wife of this man who died. You will fill it. You want to be the administrator. You will list it. You fill it and list all your children. If this husband had other children out there or had another wife, you cannot exclude them. Section 3.5 of the Law of Succession Act, a child is a child for purposes of succession.
You cannot run away from that fact.
Okay, I can see how the other children come into play, but how do you determine the other wife? In terms
Now,
of the
the other
legalese?
wife, now it brings us to the topic on marriage. Were you legally married? From 1st of August 2017, the law said that the law of course recognizes all forms of marriage, may it be customary, Hindu or whatever, it recognizes. But from 1st of August 2017, the law was giving effect to the provision constitution, says that all marriages must be registered. What does that mean? It means for you to claim that you're legally married, you need to have a marriage certificate. Whether you did the traditional ceremonies for dowry payments and whatnot, and you've stayed with this person for 20 years, you've never done like a church wedding, because most people think that registration of a marriage is doing like a church wedding. It's not. What the law
So
requires...
the traditional ones are the ones, like even where we come from,
yeah.
the community says, once you've done the traditional one, now
From your community, yeah. They call it koito, yes.
Yes, they call it koito.
I know, yes. Yeah. So, in as much as you've done that koito and you have all the photographic evidence of how the event was nice and how people danced and how you ate cake, that does not qualify to be a proper marriage before the law. What you need to do is go to the AG, mostly they call, back in the village, they would say at the district commissioner's office. You go there and apply to get a marriage certificate. You don't need to do a ceremony to get a marriage certificate or to get your union legally registered. You don't need that. All you need is go to the AG, the Office of the Attorney General, or at the DC's office, mostly that's where the devolved office is. Apply to get the marriage certificate so that in case anything happens, you're not there trying to bring sideshows and say, oh, he was my husband, and you have nothing to show. But for children, even the children, probably you adopted children, or you came to the union with other children and you as a family started taking care of these children as your own. You take them to school and do everything. You're like their guardian. Those children are entitled.
But the law recognizes polygamy now, right?
Yes, more. So it recognizes.
Under what parameters?
The parameters are to the effect that, Kitambo, or the Marriage Act, before it was amended, they were saying if you conduct a polygamous marriage, you cannot convert it to a monogamous marriage. That was to mean if you did a church wedding, you were prohibited to add wives another wife, husbands. Yeah. But right now, it's not like outrightly saying you're free. It's saying all unions must be registered. So what that means, if I'm married today, go register with my husband, though I've not seen it happen, get somebody else, they can go register.
That will not be bigamy.
Now, no, not me. It's my husband now if he gets another wife.
Yeah, that guy.
Yes.
It would not be. I thought there was a law prohibiting specifically that you cannot come to with a certificate from
the AG.
From two different,
Exactly. Now that's why I'm saying the law is
marriages,
not like
so
outrightly saying
Yeah.
you can you're given a go ahead. It is just open like that. But that's why I said I have not seen it happen. But the law, what the law is strict on.
So there's some ambiguity.
There's some ambiguity.
Why these things are in court and they're so.
Yeah, definitely, because everyone will be trying to show I was legally married to this person, and to try actually before that provision for August 2017 came into force, the issues in court were so complex. And I think what that provision did was to limit. It was trying to cure that gap that for everyone is really fighting so hard to prove that I was married to this person. To some extent, I would say it's tried to bring some order in how we approach the courts with issues to do with matrimonial property, succession mostly.
Let me ask you before you take the break. How easy is it if families are already in agreement? There was no will, but a family is already in agreement of what mzee or mama would have liked. And when they're approaching succession, they're approaching it in the units manner.
It's actually very easy. And I would really encourage that. Because if we are all in agreement, we are not disinheriting anyone, we are not giving somebody, okay, you can agree to, give somebody a bigger share or something. If the family is in agreement, what you just do, you file the petition. You will all the beneficiaries listed in that petition will need to appear in court physically, all of them, at the same time. What you will file in court is what we call a mode of distribution. You have agreed on how these are the properties and this is how we want them to be distributed. The court will ask all of you at the same time. You can't come one today and then the other one tomorrow. Just come all of you with your identity cards. If they are children, come with you parents will come with the children, and the court will ask all of you individually, not collectively. As many as of these opinions say hi. No, it doesn't work like that. Akuna. You'll be asked individually. Levi Kones, do you agree with this mode of distribution? If you do not remember correctly what the mode says, it can be read out to you, and you'll say yes. Your brother, your sister, everyone. If everyone agrees, then the court will they will have no option but to give you the grant. But before you get now the grant, they will give you it will take like 6 months, because you don't know if there were any creditors or if the person who died, probably if it's your father, had any liabilities. Because what you should actually be sharing is the net estate after all the liabilities have been sorted.
Oh, there's that?
Yes.
So hakuna kulenga?
Hakuna kulenga eti now that this person died, you write off the debt. Hakuna write off. There is no write off.
Oh my goodness. They say they only guarantee 2 things in life. Death and taxes.
Yeah, taxes will follow you to your grave. They will.
We'll be coming right back after these messages. We are talking to Grace NTEERE. She's an advocate of the High Court, talking to us about some of the things that you need to know about the law, and especially on matters of succession. Don't go away. We're coming right back.